Is arbitration the solution to the rising number of IT-related disputes? This question will be answered in a moment by Jakub Wardyński, advocate, partner in Wardyński & Partners dispute resolution practice. Then I will present a short report on what has recently happened in the Polish economy. Welcome to the program News from Poland, Business and Law. We created for foreigners acting as board members in Polish companies, foreign investors in Poland and their foreign advisors.
Hi! In this episode, I'd like to talk about the growing number of disputes concerning IT projects, what is the best method of resolving them, and why, in my view, it's arbitration. Far from hindering the ongoing digital transformation of Polish companies, the pandemic has put the process into overdrive. Major corporations are no longer the only group interested in digitally transforming their businesses. Many small and medium-sized enterprises have also chosen to embrace the process, creating a sharp spike in demand for IT business solutions after an initial slowdown. One of the major aspects of digital transformation is the implementation of IT systems designed to manage business processes of a company, particularly major enterprise resource planning systems, which are intended to manage in an integrated manner all core business processes of a company, such as HR, manufacturing, supply chain, services, procurement, and others. IT or software implementation projects are, however, notoriously difficult to complete. A well-known study by the Standish Group, the most recent one from 2015, has shown that only 29% of such projects end with a full success, with 19% ending in complete failure, and the rest facing various challenges along the way. This is particularly true when complex systems, such as ERP-class ones, are involved. One of the most infamous examples of a failed implementation project was a recent attempt by Lidl, a popular European grocery store chain, to introduce an ERP system in its branches. The project lasted almost 8 years, in the end costing Lidl approximately 500 million euros, with the company's management choosing to pull the plug on it in late 2018. Disputes over IT projects are therefore quite common. The projects either fail to keep on budget, on time with the agreed schedule, or to achieve the expected results, ending with one or both parties aggrieved and seeking some form of remedy to the problem. Historically, in Poland, most IT-related disputes were resolved amicably, with parties able to reach some form of negotiated deal without having to resort to litigation. This is beginning to change, however. In more and more cases, companies find themselves unable to negotiate a mutually satisfactory settlement. This may be because, despite the high demand for such projects, companies ordering the work are operating on much tighter budgets and find it harder to agree to bankroll problems. On the other hand, suppliers also appear to find it harder to convince customers to compromise, with the usual promises of preferential terms in future projects proving not to be as enticing as before. Disputes over IT projects are therefore likely to become more commonplace, or at least more visible and contentious. Companies would do well to consider in advance what dispute resolution methods are available to them, and particularly, what are the alternatives to court litigation or negotiation. One such alternative, namely arbitration, has been long overlooked in the business, but may be uniquely suited to the type and nature of disputes usually occurring in IT. Arbitration is essentially a private method of resolving disputes, an alternative to state courts. The parties to a dispute appoint a third party to resolve it, the arbitrator or arbitrators. Unlike a mediator, however, the arbitrator actually has the power to decide the outcome of the dispute, rather than having his or her role limited to facilitating settlement discussions. The parties can agree to shape the actual arbitration procedure almost in any way they like, to make it suitable to their needs. Your project was run bilingually, and you don't want the hassle of having to translate all the documents into one language for the arbitrator to review? Perfectly acceptable choice. Maybe you don't want the trouble of an open hearing, and just want the arbitrator to decide based on the documents themselves, rather than spending time questioning witnesses? That can be agreed as well. The arbitration process is consensual, deformalized, and highly flexible. For these reasons, it often proves more time and cost-effective than litigation before state courts. It's also well suited to resolving international disputes between parties seated in different countries, since arbitral tribunals are by design neutral and their awards are enforceable in almost any country in the world with just a minimum of formalities. Most importantly, however, the high flexibility and consensual nature of the arbitration process, particularly the fact the parties can choose whomever they want for their arbitrator, makes it particularly well suited to resolving IT project disputes. Disputes in IT most often resolve around technical issues, such as questions of whether a particular requirement of the customer remained in scope of the original agreement, or if a particular project milestone was achieved on time and meets all requirements for formal approval. Technical or industry-specific know-how is crucial to being able to understand and resolve these kinds of disputes. In arbitration, the parties can address this at an early stage of the proceedings by choosing as their arbitrator a person that has the necessary knowledge or expertise to handle the case. Should you or your organization find itself preparing for a major IT project, consider choosing arbitration. Keep in mind, though, that the choice of arbitration needs to be explicitly agreed by both parties. The most common way to document this is to include a short arbitration clause in the main contract for the project, which stipulates what sort of disputes will be covered by, which arbitration institution would organize the proceedings, what would be the number of arbitrators deciding the case, and other formal issues. Technically, it's also possible to sign a separate arbitration agreement even after a dispute has already arisen, if you can get the other party to agree to it then. In that instance, the agreement is traditionally called a compromise. Although arbitration agreements are usually short and not overly complicated, there are certain aspects to them that are best decided with someone with practical experience of the process. Same goes for the decision whether to choose arbitration as a dispute resolution mechanism itself. Remember to consult these issues with your legal counsel before signing off on any contract.
Despite higher prices caused by inflation, the number of people visiting shopping malls has almost returned to the level before the COVID-19 pandemic. The influx of refugees from war-torn Ukraine contributed to the strengthening of the condition of Polish retail trade. That's 1.5 million of new consumers. For now, it is not apparent that the war in Ukraine has caused, among foreign investors, a decline in demand for Polish commercial real estate, warehouses and office buildings, because negotiations on such transactions usually last from 6 to 12 months. Such a decline may not become apparent until the end of this year. The blockade of Ukrainian ports by Russia could be bypassed by exports from Ukraine via Poland. Until now, however, Poland has not become Ukraine's window to the world, because the capacity of border crossings was not designed for the flow of such a large amount of goods, and transport is additionally hampered by the fact that railway tracks in Poland and Western Europe have a different, smaller gauge than the tracks in Ukraine, so it takes longer for a train to cross the border because it requires a change of the wheelbase. Thank you for watching this episode. See you next time.